plant variety protection, intellectual property rights, really, they are entrenched in interdisciplinary spaces, and anyone interested in those subjects would benefit from reading broadly. Intellectual property rights and legal frameworks have a fundamental role to play in food systems and food value chains. So they inform, for example, how seeds are grown. And through plant variety protection systems, they inform how food is distributed. So we have food safety laws, we have food labeling laws, all of those, we have sanitary and phytosanitary standards, all of those inform how food gets to our table. So I'll say that intellectual property rights and general food laws have a key role to play in how food gets to our tables and how we consume the food that we consume.
Welcome to another fresh episode of your usual podcast, NextGen Agro Talks Podcast. Oladapo Folarin, and with me is my co-host as usual.
Folarin Okelola, it's a pleasure to be here again.
Thank you very much. And today we have a special, well, all our guests are always special anyway, and we'll be looking at, what the law says concerning agriculture, or what the law says concerning agricultural seeds globally, and also regards to Africa and probably the UK as well. We'll let her introduce herself.
Thank you very much for the kind invitation. My name is Titilayo Adebola. I'm a senior lecturer in law at the University of Aberdeen. I'm the founding editor of Flora IP and an editor on agronomics law.
Oh, wow. You wear so many crowns. Thank you for being our guest today.
Yeah, she wears so many caps, and I think it's a pleasure to have you. And we'll be talking, on a topic that is quite different from all the ones we've done in the past. So I will start with, trying to our audience to get to know what brought you into this field. Looking at you, you are a duly qualified lawyer in Nigeria and the UK, and a leading academics in IP law, intellectual property law. So what drew you specifically to the world of food and agriculture, because that had been your niche? Can you tell us about how you came into this area?
Thank you very much. That's a beautiful question. And just to clarify, I'm qualified in Nigeria, but I'm not qualified in the UK. So I'm an academic in the UK. But I would say that I've always loved food. I've always loved eating food. I've always been curious about food and agriculture. I've always been fascinated about food ecosystems. And I studied law for my first degree. And when I went to the United Kingdom for my second degree in law, international economic law at the University of Warwick, I was delighted to learn about the intersections of food and international economic law. I took a class on intellectual property, and one of the topics that drew me in was on seeds, intellectual property for seeds and plant varieties. And I learned about the hardware of seeds and the software of seeds, and how the software of seed is protected by intellectual property rights. And that just caught my attention. And that was where my love for the food and agriculture related aspects of international economic law commenced.
Wow, that's interesting. And I think that will lead me into my second question before my partner will come and, ask you questions. So for our listeners who might think agriculture is only about farming, how would you describe the role of legal framework and intellectual property, what they play, in the food on our plates?
Intellectual property rights and legal frameworks have a fundamental role to play in food systems and food value chains. So they inform, for example, how seeds are grown, and through plant variety protection systems, they inform how food is distributed. So we have food safety laws, we have food labeling laws, all of those, we have sanitary and phytosanitary standards, all of those inform how food gets to our table. So I'll say that intellectual property rights and general food laws have a key role to play in how food gets to our tables and how we consume the food that we consume.
Oh, that's great. Thank you very much. While I was going through your profile, I saw that you are you're senior advisor to the United Nations on special rapporteur. Is that right?
Yeah, that's correct.
Yeah, special rapporteur on the right to food. Yeah. So I would like our viewers. I would like to tell our viewers, how do you see the legal protection of seeds directly impacting global food security?
Thank you. So food security, availability of food, accessibility, stability have an important role to play, or has an important role to play in how we access food. And one of the mandates, or one of the commitments of the current United Nations Special Rapporteur on the Right to Food, Professor Michael Fakhri, is ensuring that the right to food is conceptualized in ways that also include farmers' rights. So farmers' rights many times have been marginalized and have been sidelined in legal frameworks and in conversations around the legal protection for plant varieties and seeds. And one of his thematic reports was primarily dedicated to seeds and plant varieties. And one of his recommendations to the Human Rights Council was ensuring that farmers' rights remain at the center of conversations around the right to food, and that countries all over the world should incorporate provisions in the Food and Agriculture Organization's International Treaty on Plant Genetic Resources for Food and Agriculture. So when we are thinking about access to food in the form of food security, it is important for us to also have by the side conversations around farmers' rights, because farmers provide the main sources of the food that we eat. And whenever we have improved varieties of any types of plants or crops, they actually originate from the farmers first. So one of his important contributions to the discourse on food security is ensuring that we also put farmers' rights at the center.
Okay. Yeah, so it's good you mentioned farmers' right. What would you say is the difference between farmers' right and plant breeders' right?
Thank you. So we have two core international treaties that govern the space around plant breeders' rights and farmers' rights. So we have the International Convention on the Protection of New Varieties of Plants, UPOV, and we have the International Treaty on Plant Genetic Resources for Food and Agriculture, the ITPGRFA, which is housed in the United Nations Food and Agriculture Organization. UPOV primarily protects plant breeders' rights. So it says that for you to have protection as a plant breeder over a new variety of plant, your plant variety has to be distinct, it has to be uniform, and it has to be stable. It also has provisions on commercial novelty. The International Treaty on Plant Genetic Resources, on the other hand, provides for farmers' rights. So under Article 9 of the ITPGRFA, it recognizes and rewards the contributions that farmers have made historically and in contemporary times to the development of plant varieties. So farmers' rights really provide that all of the contributions that farmers make to the development of plant varieties should be recognized and should be rewarded. However, the provision provides latitude and flexibility. So it gives national governments the space to define and construct farmers' rights in ways that best suits their national needs and priorities. Countries have defined farmers' rights in different ways. India, for example, provides that farmers' varieties should be protected as intellectual property rights. So they have a version of their registration system that allows for the registration of farmers' varieties. They also have provisions that are based on access and benefit sharing. So those provisions state that if farmers' varieties are going to be sourced for improvement, if they're going to be used as the basis for new varieties, then those farmers should have a benefit sharing structure, which could be either monetary or non-monetary. So countries have conceptualized farmers' rights in different ways. So I'll simply say that plant breeders' rights primarily focus on industrialized, commercialized agricultural systems, while farmers' rights put the farmers, mainly the small-scale farmers, at the center of their recognition and reward systems.
Wow, this is elaborate, and I'm sure that our audience are being enlightened. It will be new for many people hearing that farmers have rights and breeders have rights. So thank you, Debola, for this. I will go forward to say, today many African nations are currently updating their seed laws, which are the domestic realities that the global north often overlook when applying their seed laws in Africa. So how can we design IP system that rewards innovation, at the farmers of new plant varieties without making those seeds, unaffordable or inaccessible to the next generation of small-scale farmers? I think that's the fear of many African farmers. So how do you think, from your experience, can we do this?
Thank you. That's also a brilliant question. So I'll say that firstly, we have to think about our food systems in Africa. So if we're thinking about designing intellectual property rights systems for new varieties of plants, we have to think about the sources of our plant varieties on the continent. What do we eat? Why do we eat what we eat? How do we grow what we eat? And how can we ensure sustainability? How can we ensure resilience in the face of climate change, for example? And how can we ensure that the food that we eat is nutritionally beneficial to our populace, right? Those are some of the questions that we should ask. And when we answer those questions, we realize that we have many times, for certain types of crops, 70 or even 80% small-scale farmers that are engaged in the growing and the development of those crops. That would mean that if we were to design a plant variety protection system, that plant variety protection system should include those small-scale farmers that produce the food that we eat. They should protect the interest of the small-scale farmers that understand the local terrains. They should protect the interest of the small-scale farmers that have conserved those varieties for generations and that continue to ensure that those varieties remain accessible for planting. And when we want to do that, we would realize that it would be important to provide for the protection of plant breeders' rights alongside farmers' rights in Africa. So I would say, in thinking about a plant variety protection system for Africa, we should think about an inclusive plant variety protection system. We should ensure that the system is also sustainable, and we should ensure that it is resilient. And I would say some of the core elements would be to have the protection of plant breeders' rights, to have the protection of farmers' rights, and to have the protection of traditional knowledge in relation to plant genetic resources. When we have that combination of rights, then we're sure that we're protecting the very source and essence of our food on the continent. And we have an example. We have an African model law under the Organization of African Unity, now African Union, that has provided a template, has provided a guide. Professor Johnson Eperi was one of the lead protagonists of that law. He's Nigerian, alongside a lot of his colleagues that worked at the African Union, the OAU at the time, and they have produced a guide that can be beneficial. It's a living law, so it's a law that has to be adapted. So you might not have to take the law wholesale, because there have been developments over the years And so I would say that those are examples, that we could draw from. The African model law is one example that we could draw from. We could also draw from other jurisdictions. We could draw from India, what India has done. Thailand has also introduced a similar law that ensures that farmers' rights and traditional knowledge are protected within their legal framework. So those could be examples of inclusive, sustainable, and resilient systems that will be suited to the African context.
Very interesting. Those three words are very important: inclusivity, sustainability, and resilience. IP system or IP system. Yes, because you are talking of farmers and plant breeders, right, at the same time.
All right. So right now, if you look at the global space, agri-tech is developing and growing. So with the rise of agri-tech and data-driven farming, what are the emerging intellectual property challenges, regarding who owns data generated on the farm, if there are any, or do you think there will be any, in the future or present?
Thank you. So I'll say one of the core questions that the stakeholders within the space would have to consider is the contractual types of relationships that arise. So it will be contracts. When data is generated on the farms, many times it really depends on what contracts the stakeholders have signed. If you have a contract that states that a technological platform would own all of the intellectual property rights that are generated as a result of sourcing data from the farm, then the contract would hold, right? So I would say that one of the important factors that would need to be considered would be the contracts that are signed in those agri-tech types of relationships. When data is generated, many times it is the person in charge of providing the software, is the person in charge of providing the tools, the infrastructure that might want to have the protection. So what would be important would be for the stakeholders to have clear contractual agreements to state what the relationship would look like. So I'd say that it lies mainly on contractual laws.
Okay. So like you mean like contractual obligations, between the parties involved, right?
Yes. So what have you signed?
Okay.
What have you decided? What agreement did you reach, right? Those that would inform what the relationship would look like.
Okay. All right. Thank you very much. Another question I would like to ask, based on one of the things you mentioned while you're answering one of the previous questions. You mentioned traditional knowledge. Yeah. So how do you think the law can protect this traditional knowledge in terms of agricultural knowledge or wisdom that has been passed down, from generations to generations? How are this knowledge being protected, or how can they be protected from being exploited, by commercial interests?
There are different ways to protect traditional knowledge. Traditional knowledge can be captured under plant variety protection laws. So we could say having an inclusive plant variety protection law includes the protection of traditional knowledge related to plant genetic resources. We could say that we're protecting community rights that include traditional knowledge. We could say that when farming communities develop a variety or conserve a variety based on traditional knowledge, that they have protection for a certain duration. So we could have the protection of traditional knowledge incorporated in plant variety protection systems. We could also have the protection of traditional knowledge incorporated or embedded in patent systems. So disclosure of origin. We could say that if a patent is going to be registered, then we want the origin of the invention, if there are any links with traditional knowledge, we want that to be fully disclosed. And with that, we'll be able to conduct a substantive examination to see whether the potential invention really meets the novelty condition of patents. Because for you to have an invention patented, it has to be novel globally. So if we have a disclosure of origin provision, that would mean that if the invention is not novel, it will not meet the condition for patentability. We could also have the protection of traditional knowledge under geographical indication systems. So geographical indications protect products that are linked to a particular place. So for example, Oku white honey is linked to Cameroon, or Penja pepper is linked to Cameroon. So you could, a particular territory, a particular jurisdiction within the country, due to some essential attributes, some characteristics, reputation, and that could be based on traditional knowledge. So you could have a geographical indication in a system of protection, right? Many examples of geographical indications are that people are familiar with sometimes could be those outside Africa. So if I say Uku white honey, Penja pepper, many people might not know. But if I say champagne, many people might know champagne linked with a particular region in France. If I say Scotch whiskey, many people would know of Scotch linked to regions in Scotland, right? So having geographical indications would be one other example of protecting knowledge systems that are essentially attributed to a particular territory. So I'll say there could be multiple layers and ways of protecting traditional knowledge, and I've given you some examples.
Okay, thank you very much. I would take my next question from something you say. You said earlier about contractual agreement and what our farmers are signing, and what was coming to my mind is with the level of education and ignorance in Africa. How would you think we can create awareness and let our farmers see the importance and relevance of whatever they are signing, because this has to do with intellectual property protection. So is this something you've been looking at, or is this something you have a suggestion of how, it can be addressed?
Thank you. Yes, so I'd say that it's something I'm interested in. Now we have emerging conversations around digital sequence information. So many times for some plant genetic resources, you actually don't even need to go to the farm. You don't need to physically have access to it. You can have access to those plant genetic resources and information in digitized formats, right? So and this is a conversation, negotiations that we have that is ongoing at the Convention on Biological Diversity Secretariat, at the International Treaty on Plant Genetic Resources for Food and Agriculture Secretariat, about the best ways to regulate, to govern digital sequence information and the digital materials in plant genetic resources. I would say that national governments have a fundamental role to play in protecting the interest of small-scale farmers. So, for example, when materials are going to be sourced from farmers, I would say that rather than the farmers dealing directly with the external actors, the external bodies, there could be regulatory frameworks in place that could ensure that the interest of farmers are protected. So in Nigeria, for example, I know that we have our Ministry of Environment, and the Ministry of Environment should be responsible for provisions around access and benefit sharing. So access to plant genetic resources and plant genetic materials in Africa. So whichever actor or stakeholder, organization, company that wants to access genetic resources from Nigeria, they're expected to go through the relevant officials and relevant regulatory processes as established by the Federal Ministry of Environment. So I'll say that governments, the national government have a fundamental role here to play. And perhaps they could also be orientation conversations. There could also be capacity building with our farmers to educate them about the importance of not disclosing information related to their genetic resources without authorization of the relevant bodies.
The next question is, you are an editor, a director, an advisor, a professor, maybe also you are a farmer. Let me add that. So what advice do you
The
have
senior
to students who
advisor.
want, yeah, who want to bridge the gap between science and agriculture and law or policy? Because you wear a lot of caps. So what advice do you have to the young ones, that are listening to us and they are thinking and wondering, how do we, bridge the gap between all these areas?
Thank you. So I would say that it's important to learn. So it's important to move beyond disciplinary silos. If your background is in law, for example, it's important for you to read and learn about the contextual factors that are relevant to whatever area or whatever discipline that you're interested in. For me, I would read books on agriculture, I'll read books on the environment, I'll read books on technology to understand how the systems that I'm interested in, how they work. So and many times in our teaching now at university, we are embracing interdisciplinary teaching. So we're embracing teaching that ensures that students are learning from different disciplines. So if I'm teaching you plant variety protection, I would like to have a plant breeder, someone that is grounded in the science of the subject to explain some of the fundamental factors that would be relevant for you to understand how plant breeding works and how plant variety is developed and designed. And this could also be done by interacting with colleagues and peers, right? So even beyond what happens in schools and in the classrooms, you could learn from your peers, you could learn from research, you could conduct research online, you could read books from other disciplines. So I'll say that reading broadly expands the brain and expands our knowledge and just really helps to bridge gaps. And it's, you might not fully understand it from day one, but I think that curiosity, once you've taken a subject and you're curious about it, you would want to learn more about it. And I think that really is the magic. And I would say that it's even applicable to other areas now. So even if I'm studying intellectual property, I cannot study it without understanding history. I cannot study it without understanding geopolitics. I cannot study it without understanding the political economy, because all of those inform how a plant variety is protected in a particular jurisdiction and what the interests are, in other jurisdictions, and why some laws are designed the way that they are. So I would say that plant variety protection, intellectual property rights, really, they're entrenched in interdisciplinary spaces, and anyone interested in those subjects would benefit from reading broadly.
Wow. So what I can summarize is that it's not, our normal way of garbage in, garbage out. You don't have to be a stereotype. You have to be, very fast in and think outside the box. Although someone recently said that there should be no box at all. Why not take the box away? So thank you, Debola. You've really enlightened and educated our audience. Finally, from me, I would said, you founded Flora IP as a resource for food and agricultural law. What inspired you to start this digital platform, and how important is knowledge translation for the future?
Thank you. I would say that question neatly fits with the previous question that you asked. when I was finishing my PhD at the University of Warwick, I was grateful for the resources that I found online. I was grateful that I could check for how maize is bred and I could find information about that. So I remember talking to one of my close friends and I told her that if I search for information that I usually find it right online, that I also want to contribute to that pool of knowledge, that what I know about food, about agriculture, about intellectual property, I'd like to also share that. And so I got a grant from an institution at Warwick and I organized a conference that brought together stakeholders from food, from agriculture, and from intellectual property institutions globally. And that was one of the founding blocks for Flora IP. And since then, I've interviewed different stakeholders around the field, and I've also written post information articles, news reports related to food, agriculture, and intellectual property. So it was my way really of also contributing to the global knowledge pool within the food, agriculture, and intellectual property space.
Oh, thank you very much. That's really interesting. As we bring this, to a close very soon, if you could change one global law tomorrow to make the agricultural system fairer for the next generation, what would it be?
It would be the International Treaty on Plant Genetic Resources for Food and Agriculture. I'd like to see firm enforceable provisions on farmers' rights. I'd like to see a firm guide on what farmers' rights should look like. And I'd like to see more contracting parties implementing inclusive farmers' rights systems.
Okay, that's great. Thank you very much. It's been a wonderful session with you. We're very glad that you're able to make this interview. But before we go, I would like to ask two fun questions. Just we might call them rapid fire, or two fast questions. What would what would you say a book or a resource every next gen agri leader should read? What book would you recommend?
So I have maybe two books: Global Biopiracy, Patents, Plants, and Indigenous Knowledge by Professor Ikechi Ngbeoji. This is the book. So that's
Okay.
one. And the other is by Professor Jack Kloppenberg. It's First the Seed, the Political Economy of Plant
Wow.
Biotechnology. So I'd say those
How long
two.
do you think it's gonna take me to read this one?
It'll take a while, but once I read those books, I think that was when my research fully
Yeah.
commenced.
Yeah, thank you very much. And so the next one will be, what's the most common misconception people have about intellectual property?
Many people think intellectual property is complex, and I'd say it's not. It's thoroughly enjoyable to read, to understand. Once you start exploring it, you would find your feet, and I think that you would enjoy it, right? So many times people just set aside intellectual property rights because they think it's technical, they think it's just for certain specialists. But I'll say that intellectual property is fun. So more people should come learn about intellectual property.
Thank you very much. I know I used to be on the path to learning about it. I think I should continue my learnings.
And thank you very much for the kind invitation. I think you're doing a brilliant job with the podcast, and I wish you continued success. Thank you.